Hello, everybody. Good afternoon and welcome to this lunchtime webinar on Professor Stephen Mason's second supplementary report to the Independent Review of Legal Services Regulation. My name's Anna Donovan. I'm the Director of the Centre for Ethics and Law and an Associate Professor of Corporate Law here at UCL Faculty of Laws. The Centre for Ethics and Law is delighted to host today's webinar, which brings together a number of distinguished speakers to discuss what is, I'm sure we will all agree, a very timely and important report. Time does not allow me to do full justice to our speakers' biographies, which are available in full on the event registration page. However, in brief, I'm honoured to be joined by Professor Stephen Mayson, Honorary Professor of Law here at UCL and bencher at Lincoln's Inn, where he's also chair of its regulatory panel. Sam Eastwood, a partner and anti-corruption expert at Mayer Brown. Sam is a board member of Spotlight on Corruption and a member of the steering committee of the Institute of Business Ethics Task Force on Business Ethics and the Legal Profession. Dr. Karen Noakes is a lecturer in professional ethics here at the Faculty of Laws and co-investigator on the ESRC-funded project Professional Pathologies, Causal Pathways, and the Post Office Miscarriages of Justice. Today's event will follow more of an in-conversation style discussion, meaning that Stephen will start today's discussion by introducing the report for about 10 minutes, following which Sam will offer his thoughts on the report and discuss key aspects of Stephen's report with him. Thereafter, Karen will similarly share her perspectives and explore pertinent aspects of the report with Stephen. Time permitting, the webinar will conclude with a Q&A section, so do please feel free to send some questions in using the Q&A function at any point in time throughout these proceedings. I will moderate the Q&A session and we will attempt to ask the speakers to discuss as many of questions as time allows. Please note that today's event will be recorded and the recording will be released on the Centre's website shortly. So with that, I'm now delighted to hand over to Stephen.
Thank you, Anna. Welcome to everyone, and thanks to the Centre for hosting this webinar today. I thought I'd start with a little bit of background before getting on to the specifics of the third report, which we're really here to debate. This report was prepared as the third in the Independent Review of Legal Services Regulation. The review started in 2018 as a response to the Competition and Market Authority's own market study, where the CMA concluded that the legal services sector was not working well for consumers. And it also said that the regulatory framework of the Legal Services Act of 2007 was not sustainable in the long term. The government obviously had Brexit to deal with, declined at the time to decline the CMA's invitation to carry out a fundamental review of the legislative framework. So under the auspices of the Centre of Ethics and Law at UCL, I undertook to do so voluntarily. The main report was published in June 2020 and submitted to the then Lord Chancellor, Robert Buckland. It recommended both short-term and long-term reform of the Legal Services Act. Conversations began immediately with the responsible minister and officials in the Ministry of Justice and with regulators and other interested parties. Interestingly, though, it soon became clear that although we all agreed that a major role of regulation is to avoid or mitigate consumer harm, the notion of consumer harm in legal services was itself variously understood. Further work therefore took place, and 2 years later, in April 2022, the first supplementary report was published, looking at the meaning, nature, and consequences of consumer harm. And it concluded that there was significant detriment to consumers. This was being caused first by the inability of the current regulatory framework to provide any meaningful protection to consumers for harm arising from the provision of usually non-contentious legal services, provided perfectly legitimately by those who are not regulated as lawyers. The second source of detriment to consumers comes from regulated providers. This harm might arise both for those the lawyers act for and those they act against. And this variously includes lawyers who are incompetent, dishonest, overcharging, providing poor service, being aggressive, or bullying. And although the regulators can take direct action against them, regulation does little to offer accessible and meaningful redress to the consumers who suffer the harm. So we come to the third report, published in September this year, the second supplementary report on the meaning of the public interest. And it takes a central recommendation of the review's main report, namely that promoting and protecting the public interest should be the principal objective of legal services regulation, and within which consumer harm is then protected. It sets out to address the common response that the public interest is too nebulous or fluid a concept to be useful to regulators and practitioners. So the three main conclusions of the report are: first, in relation to a definition of the public interest. The report reaffirms an earlier definition of mine that the public interest has two principal dimensions. The first is maintaining the fabric of society, which for our purposes includes the rule of law, the administration of justice, and public order. And the second dimension is securing the legitimate participation of citizens in society, which includes access to justice, equality, and the protection of their legal rights. The second main conclusion related to the role of lawyers. There's a parallel but equally important element of the report alongside the public interest, because it also affirms the idea that lawyers should see themselves as members of a public profession. As such, they must recognise that the status and privileges they enjoy as members of a profession are the result of the licence to be a profession. And this licence is granted to them on behalf of society, that is, on behalf of the public. Consequently, they owe a primary duty to society to secure the public interest ahead of clients' interests and self-interest. And this includes upholding the rule of law, acting with integrity, independence, and in the interests of justice, and ensuring access to justice, and certainly not frustrating or denying access to justice. So the third main conclusion, and the thrust of the report really, is that the coming together of these two issues of a public nature, the public interest and a public profession, means that law is more than just a profession. It's about more than just serving clients, more than just acting as an officer of the court, and more than just doing what is proper under the strict letter of the law. It's about public service and stewardship of the public interest. The privilege of a profession is conferred on behalf of the public, and therefore its members have a reciprocal obligation to serve the public, society, and the public interest. So they were the three main conclusions, and the report then went on to examine some recent public concerns, very public concerns, about the ethics and behaviour of lawyers. And the report picked out four things: enabling or facilitating kleptocracy and grand corruption, so the way in which funds are obtained and moved corruptly across country borders with the help of financial and legal professionals. The second concern was engaging in abusive litigation and aggressive tactics, including strategic litigation against public participation, known affectionately as slaps, used to shut down public revelations or criticism. Third is the questionable use of non-disclosure agreements, or NDAs, to cover up persistent misbehaviour of the sort that we saw with Harvey Weinstein, possibly Mohammed El-Fayed. And fourth, the pervasive misconduct emerging from the Post Office Horizon inquiry, which also includes the misuse of NDAs, but many other things besides, all of which seem to come together as good examples of instances where the public interest is not being pursued, unknowingly not being pursued by lawyers. Now, I know that Sam and Karen will want to pick up on some of these, so I'll leave it there for now. Thanks, Anna.
Thank you, Stephen. Sam, perhaps if I can turn over to you.
Yeah, so there's a blog on Stephen's website, which I commend to you, and the title is, "Are You Proud to Be a Lawyer?" And he ends his thoughtful piece, which ultimately is an excuse to talk about the report, which I certainly commend, with the following. If lawyers can recapture their identity and commitment as members of a public profession, with its primary duty to serve the public interest ahead of client interest and self-interest, then there remains hope that the public perception and standing of lawyers can be restored. At that point, Stephen concludes, I could say with confidence that I remain proud to be a lawyer. Anna, in her introduction, referred to the fact that I'm a member of a task force, which Stephen is also participating in. And the task force, which is set to issue a report in January, has examined the rules, practices and approaches used by the UK's legal profession in relation to choosing which clients to represent. And it does consider the basis for new approaches to the way in which ethical standards might be developed in relation to such choices. The context for the task force is the concerns expressed by civil society and others that corrupt oligarchs and kleptocrats use the services of UK-based law firms to consolidate their wealth and bolster impunity for their actions. And indeed, Stephen referred to that as one of the mischiefs that is causing sort of public concern. What I can say is that the impact of Stephen's analysis of the law as a public profession and the concept of public interest has been significant on the task force's thinking and its recommendations. So just some quick observations, then I'm going to engage with Stephen on what I think is the sort of killer point, which is so what? What are we going to do next? I would say, from my own experience and consistent with the task force findings, my sense is that the concept of law as a public profession does not currently permeate modern legal practice, and it should. I think it's also the case that public interest doesn't currently feature in many law firms' client take-on, matter take-on evaluations, certainly not formally, and it probably should. And I would also say that lawyers would struggle to articulate what it means to be members of a public profession. And I think this paper goes some way to addressing that challenge. I think it's extremely helpful and could be the basis for fertile discussions. I would also say that reputation is certainly a factor that is taken into account by law firms, and that's an important balancing factor, which goes some way to addressing Stephen's challenge, which is the public interest challenge. But it is less evident that that analysis of reputation extends to the reputation of the profession as a whole, rather than the firm and only the firm, and the public's trust and confidence in the profession as a whole. And again, Stephen's paper does relate to that. My final observation, and again, I'm picking up on the task force's findings as well, is that currently law firms are not very transparent about how they address client take-on, matter take-on, and that extends to management structure, personnel and processes involved in that process. There are some exceptions. And again, in the task force paper, we have called out and recommended the exceptions. Nor are they currently very transparent about how they promote ethical and responsible conduct within the firm, which I think is dear to Karen's heart, and Karen might pick up on that when she talks about that. So I suppose those are my observations, which in broad terms is this strikes a chord, Stephen, and yes, I would like to be proud to be a lawyer, and I think most days I am, but I certainly have an interest in the debate that I hope that you have catalyzed and will continue to catalyze. So my big so what, I suppose, is if law firms are going to take the broad message of your paper to heart, then how might they practically address the challenge which you've presented, which is putting public interest at the heart of their decision-making and their culture? So that's a big question. What's the answer?
Well, yeah, thanks for that, Sam. You're right. It is a big question. In many ways, it is the important question, because if nothing happens, then we're just going to be going around in circles having the same debate for years on end. There's quite a lot to unpack here. As you say, the issues have been very much front of mind in the deliberations of the IBE task force, focused on representation in civil matters, not criminal representation. And the report is due in early 2025. And as you say, all is not lost. There are some firms who are already doing some really quite interesting and innovative things in the way in which they approach these issues. But in a way, I think all of this is probably demonstrative of the larger public interest concerns raised in and by my report. So a lot of what I'm about to say, I don't think is restricted to this issue of kleptocracy and grand corruption and necessarily the intake in those sometimes clear, sometimes marginal decisions. So in terms of addressing these things at a practical level, I think the first thing must be that a firm expresses and adopts and enacts an overriding commitment to place professional and business ethics at the core of its decisions, both to represent clients and when representing clients. So it's sort of before and during. And what that should lead to is greater selectivity in client choice and representation. And I think equally important, transparency in doing so. And that for me is the starting point of acting in the public interest. There are two dimensions at play there. One is acting, which is about the actions and behaviours, and in the public interest, which for me requires transparency. So in other words, that the acting is explained and justifiable. So the report picks up on the notion of transparency and suggests that three things are required. 3 A's as it happens. First is articulation, so that the justification should be made explicit. Second, on accessibility, so that the public, and I'd also say the employees and others within a firm, should be able to find the justification for taking on client matter or the way in which a particular cause is being pursued. And third, accountability, that the conduct can be evaluated. So articulation, accessibility, accountability. Now, what does that look like in practical terms? And forgive me, in the interest of time, I might have to take a few shortcuts here. And I'm very conscious that I don't really want this just to be a bit of a shopping list. But to take articulation first, I think firms, some already have, as you say, but firms should consider adopting and implementing explicit policies, processes, and standards. So things don't happen behind closed doors or only in people's minds. There are articulated policies, processes, and standards for client selection, and they've got to reflect the broader ethical commitment that the firm agrees to make. And the second thing is no good just articulating. You've then got to make sure that the people in the firm understand it. So there's training or dissemination going on so that people are aware of what those policies, processes, and standards are. And that's different to compliance. It's not box ticking. It's not after the event. It's something that actually gets embedded in the way in which the firm operates and then holds itself accountable. And of course, it's important that this doesn't just apply to the lawyers in the firm, but the business support and other staff in the firm need to understand how and why the firm is seeking to behave ethically in everything it does, and that what it does is aligned to the broader firm's values and commitment to ethical behaviour. On accessibility, to some extent, things aren't accessible unless they're somehow out there. So firms need to find a way of publishing in one form or another. And they may need to adjust this internally and externally, depending on the audience. There'll be some things that firms can't say externally, for instance, but that doesn't mean they shouldn't say anything. So it could set out a commitment to ethical and responsible behaviour, make that very plain, and say that it does commit to training, so that there's an explicit statement against which it can be held to account, and that'll be the third element. Statements that show how these ethical standards and responsibilities are embedded into the practice and organisational structure of the firm. Where does the responsibility fit? Who makes the decisions? How are those decisions made? How are they publicised? And also perhaps to explain how the whole structure is supposed to work in reaching and reviewing decisions on client and matter selection. So there's an explicit statement and track through the way in which the firm operates, which you can then use as a basis, certainly for internal transparency and oversight. So is there an ethics committee? Many firms have started adopting that as a way of centralizing and publicizing the way in which some of these ethical decisions are made. But town hall meetings, discussions with colleagues, the internal opportunity for conversation and discussion about how these decisions are made, rather than just being made somewhere in the abstract, and then everybody is either supposed to know, or even if they don't know, they're supposed to follow them. Some firms now issue annual reports or include ethical statements in their financial disclosures or on their website. All of these are ways in which how the firm sets out to do something can be put into the public or the semi-public domain that allows other people access to that process. And then finally, we've got accountability. This is it's a way of just making sure that having made your commitment, having told people what those commitments are and how they work, that there's an opportunity for people to hold the firm to account. Again, maybe internal, maybe external. Perhaps the lawyers who are responsible for making choices on specific client mandates should be much more willing than they've been in the past to explain how that decision has been made, how those actions have been taken, why they are, in fact, in their view, in the public interest as well as in the client interest. A speak-up culture, perhaps, inside the firm. So you encourage people to call out what they might regard as questionable decisions or questionable ethical behavior. And maybe an annual log of the number of clients and matters that are declined for ethical reasons. Not, it would probably have to be anonymized, but some metric that shows in practical terms how often these decisions are being made and how often they're being made for ethical reasons as opposed to other reasons. So I don't really want to produce a shopping list and go on ad nauseum about this stuff, but some ideas there about how articulation, accessibility, and accountability might be built into into the way that a firm operates.
So, I mean, thank you for that, Stephen. And I suppose in the sense, because I think your paper does highlight those three aspects, but maybe doesn't flesh it out as much as people might be looking for. But the answer to those people who are scratching their heads is wait for the task force's recommendation in January, which will echo many of those points and will have been influenced in large part by Stephen Mason's thinking. So thank you for that. One final question before I hand over to Karen, and you can answer this as short or as long as you want, Stephen. But your paper focuses on the UK. That's your area of focus, and the answer is it's ambitious enough as it is. But UK law firms who are part of large international practices will be sensitive to norms and expectations in other jurisdictions. We operate in a competitive marketplace. Do you have a sense of how other jurisdictions approach some of the issues canvassed in your paper? Are they also sort of addressing some sort of existential crisis about whether they are or not proud to be lawyers, or is this just a UK issue?
It's definitely not just a UK issue, that's for sure. North America often gets particularly exercised about this sort of ethical behavior. It doesn't necessarily talk about it in terms of public interest, but it does raise the same sort of concerns about how and why lawyers are acting in certain ways, or even acting at all. But it's probably fair to say, if you look globally, it's a bit of a mixed picture. I mean, there's some jurisdictions where lawyers would be openly hostile to the idea of acting in the public interest. It's just not part of their conception of being a lawyer. And even in those jurisdictions where lawyers are not hostile, the UK is probably the one that talks about it most, but when you look at the actual behaviour, it's probably no better or worse than any other jurisdiction for the way in which lawyers do or don't pursue client and public interest. But so there are differences, and you're right. I think for firms that practice in multiple jurisdictions, that can be quite a challenge, because there's no dominant professional or firm philosophy necessarily globally that would allow some of those decisions to be made. I mean, there are other academics, particularly in North America and Australia, who look at this question of professional ethics. The International Bar Association has tried to find common common ground or expression of these fundamental professional obligations. But probably fair to say, because it is international, it's struggled to find that common ground and express it in a way that's acceptable to everybody, and I think continues to do so. So I'm not sure I have the answer here, but it could be very uncomfortable, and perhaps here then more than some other circumstances, some sense of an articulated national or even personal moral compass for making these decisions might provide some comfort to an individual lawyer who's grappling with those issues. But again, it's back to the internal debate. Where does that debate happen? On what principles are the decisions made internally, especially perhaps where there are different national views, and where can the whole firm take some sort of guide or comfort from the decisions it makes about who to act for and on what?
Yeah. Well, look, thank you for that. I think I'm going to hand over now to Karen just to pick up the mantle.
Thanks very much, Sam. I just wanted to say, firstly, to pick up on Anna's point, Stephen, the meaning of the public interest report is such a timely report, and it should be essential reading. It should be essential reading for all lawyers, regulators, policymakers, law students, but especially those in practice who have to grapple with weighing and balancing the tensions and demands of practice every day with their professional obligations. It's a tricky task, I know. I've got a range of questions to ask you, which kind of bring out certain aspects of the report which are of real interest to me. But I firstly wanted to kind of cover 3 points of my own personal reflection from reading. Firstly, in the preface of the report, you make reference to lawyers are not just ordinary market participants whose foremost obligation is to act and secure their clients' interests. Instead, they're members of a public profession and owe a primary duty to society to secure the public interest ahead of clients' interest and self-interest. That stood out to me with bright shining lights for 2 reasons. Firstly, it reminded me and took me back to the sociological work on the purpose and the role of the professions, which I studied right at the start of my PhD quite a few years ago. It's kind of almost like a call to go back to basics, in a sense, and a reminder of the importance of the professions in general, of needing to serve social needs, and of the profession's importance to the creation and the maintenance of markets in society, of organisations, and everyday business practice too. And there's a reason why those scholars in sociology call the professions unique occupations, because they really are. And secondly, it was that the recognition of the importance of primary duties really got me thinking about occupational and role identity for lawyers. And I would really hope that lawyers reading this report would pause to think about how they conceive of themselves in their role and what duties come from that role and that identity, because identity has a huge part to play in creating and maintaining ethical culture within law firms. Which kind of brings me on to my second point, and you touched upon it a little bit in terms of some of the actions that you were talking about in response to Sam, which is the importance of culture within law firms, and indeed any organisations where lawyers work. We've got 35,000 plus in-house lawyers, of course. And we know from empirical studies in business ethics that ethical culture and ethical infrastructure are significant indicators of ethical behaviour. You mentioned also about, one of the points that firms could adapt is speaking up, and speaking up only happens in a culture of an organisation where people have psychological safety. So it's really, really important. I wanted to pick up on the point that you make in chapter 3 on the public interest and the importance of values, where you state self-interested, profit maximising behaviour, while good for some, might not be inherently good for all. And therefore, this part of the report, I think, should be a clarion call for senior leaders within organisations. In fact, leaders within law firms and organisations that lawyers work about, actually, those senior leaders taking a break to look at what are the key values and associated behaviours that we're looking for within our staff. What do we wish our firm or organisation to be known for. What you were saying about actually the public-facing part of it. The public-facing part of it is one part, but it's also about what behaviours do we want to see within in respect of our staff. A focus on the public interest and what this means for lawyers and the way that they do business and provide services and the way that in-house lawyers provide services should, I think, be occupying right now partnership boards and senior teams, especially with some of the very high profile questionable behaviour of lawyers that you mentioned earlier and you cover in chapter 9. I think the public interest for lawyers to mean that it does need individual consideration and reflection, and that means individual accountability in regulatory terms, as we know, but there's a critical role for the collective here too, a key role for organisational culture to support individual thinking and judgment vis-a-vis the public interest. My last point before I go on to my questions is I wanted to highlight, actually, you make this call for lawyers to change behaviour. And you say that lawyers' actions and behaviours count, and I could not agree more. And a recognition of the importance of the public interest in lawyering, I think, has the real potential to be influential in that behaviour change. You refer in chapter 7 to, amongst other things, the need for lawyers to be reflective, to think about what they are doing as being more than meeting the expectations of ordinary business or economic actors, of conceiving of their role as being greater than their own self-interest. And I like the reference to Gabianetta et al. In respect of having a superior moral fibre. I think if actually all lawyers thought about that, that would be really helpful. So these wider obligations to the public need to feature in lawyers' thinking and judgment as a matter of course, and not something that only features when they find themselves in a sticky spot. I think for me, the public interest should be that constant mental backdrop to everyday practice. So my first question is kind of picking up on that thinking and judgment, and it's, Stephen, you discussed the role of markets in determining behaviour, but the need to have a moral account along with markets. And for some, I know this may be a contentious issue, but does a refocus on the public interest for you therefore mean that lawyers need to engage in moral judgment as part of their professional role to discharge the higher order function you referred to in chapter 7?
In short, yes. But I think there are two principal points at which that moral imperative is most likely to be engaged. And the first, which I mentioned in response to Sam, first is the point of client or matter acceptance. So unless there's a professional obligation, which there might be for barristers because of the cab rank rule, it seems to me that it's perfectly acceptable for a lawyer to say, or a firm, to say, morally, I or we do not want to act for this client or this type of client or on this type of work. Now, of course, they mustn't fall foul of any other legal requirement like discrimination laws in making that decision. But in principle, I don't see that they should feel they can't make that moral decision. But I also then think they should expect to be questioned by others, whether internally or externally, about the principles or values that lead to that decision. And in most cases, I happen to believe that client confidentiality wouldn't prevent them from being able to respond to that inquiry. So that's the point of entry, if you like, before they even act for the client. Do I want to? The second point is where it becomes apparent during the client retainer that the client wants to do something which is morally or ethically questionable. Let's say it relates to litigation tactics. They want to go hard, or in short, they want to bully. And again, I think the lawyers or the law firm's moral compass can rightly be engaged in seeking to persuade the client that although there might not be any legal impediment to what the client wants to do, nevertheless, the lawyer's view is it would be unwise, unethical, not good practice, even not good optics reputationally for the client to do that. And that, for me, is the use of persuasion that has a moral basis. But if the client disagrees and still wants to go ahead with that doubtful but not illegal behaviour, sometimes called lawful but awful, I do accept that the lawyers at that point, having already accepted the client and the work, should then park their moral or ethical qualms and represent the client to the best of their ability. So the idea, often expressed as lawyers don't do morals, I think is just, it's too simplistic and fundamentally not right, and certainly not in this context.
So bringing moral judgment back in should be the call there. My next question is about the role of the super regulator, the Legal Services Board, and the local regulators. And in some ways, a focus on lawyering in the public interest means that lawyers who usually kind of maybe focus on the micro, right? So what their client needs are every day, if we term that the micro, kind of set against really what we could term as the macro, the kind of the public interest, rule of law, administration of justice. So lawyers might say, well, actually, my job is the micro. Lawyers might say that the macro is not for their concern, it's for the super regulator and their own regulator. What would you say to those lawyers?
I'd say something simple in response, but I hope not simplistic. So the first part of my response is that the macro is the outcome of the sum of all the micro actions. And as we've already discussed today, if the micro actions take the form of pursuing clients' needs too fervently or aggressively or abusively, then the rule of law and the administration of justice are undermined and not achieved. And at that point, the resolution of a legal issue is not by consent or by judicial determination, it's actively denied by the exercise of an imbalance in power. And I can't see that that is in the public interest. So there's that point about the accumulation of the micro is the macro. The second is perhaps a little more pointed, but the SRA's Principle 1 explicitly requires a practitioner, or solicitor at least, requires them to act in a way that upholds the public interest, the rule of law, and the proper administration of justice. More than that, the introduction to the principles also says, should the principles come into conflict, those which safeguard the wider public interest, such as the rule of law, take precedence over an individual client's interests. So for me, there should be no doubt that these macro issues are very much an individual lawyer's concern. It's abundantly clear.
My next question is, in fact, I'll make this my final question for the time being, is the need and the call to move away from what might be termed a myopic focus on the client. You make reference to Chapter 8, to something I know very well, the post office scandal, and an example of an external lawyer acting for the post office in civil litigation against a former sub-postmaster who was a litigant in person, who has told in evidence to the public inquiry that it was his absolute duty to act in the best interests of the client. So how can, in your view, Stephen, a greater focus on the public interest be harnessed practically to move lawyers away from this almost myopic focus on being what I might call seller service providers for their clients? Yeah,
and in a way, it's the nub of the issue, isn't it? It goes back to Sam's point about how do you make this happen at a more practical and prosaic level. I think the answer lies in a combination of realization, accountability, and enforcement. So there'll be no movement at all on this unless and until lawyers understand and accept that there is no such absolute duty, and that clients' interests are always subordinate to the public interest. And that might mean that the regulators need to reinforce that message even more publicly and more loudly than they have done to date. So that it's the understanding point, the realization that there is a higher duty. But then again, there'll still be no incentive for change if actions have no consequences. So that's why the report calls for the greater transparency, accessibility, and accountability that I talked about earlier in response to Sam. So we need to ensure that the public interest is protected and promoted. Maybe we can expect some objection based on client confidentiality and legal professional privilege. My response to that is let's remember that these two are granted in the public interest, and they are privileges that belong to clients, not to lawyers. So they apply to the content of their dealings with lawyers, not to the process by which lawyers make decisions and take action on their behalf. So I do think there's there's an entry point, if you like, for that accountability, public accountability, if need be. But then finally, as part of creating consequences that will encourage a change, I think regulators have got to be much quicker and tougher on dealing with those practitioners whose actions are manifestly not in the public interest, as we're now able to identify. If practitioners don't uphold the principles of a public profession with accountability to the public, they'll lose the privilege of being a profession altogether.
Mm.
That alone, for me, should be sufficient incentive to lift their heads away from the myopic obsession with their clients and their own interests.
Thank you. Thank you very much.
Thank you all for such an engaging and interesting conversation. And it's really wonderful to hear both the principal discussion and then some of the practicalities around how we can start to achieve that. We do have a couple of questions, one for the whole panel, one for Stephen specifically. And so to our audience members, do please add those questions you might have to the Q&A. The first question, which is perhaps for all, why is the question just about law firms? Is it not all lawyers wherever they work?
I'll gladly kick off on that one, Anna. Yes, it is. I mean, we're really talking about how lawyers behave, but accepting that the behavior happens within a cultural and organizational context. So yes, it is about the lawyers, but we can't ignore the effect that the environment within which lawyers practice will have some effect on their individual behavior. So it's a good question. We need to look at both ends of that spectrum, and hopefully there's enough both in the ideas of the public interest, the public profession, and the practicalities of making that real that should engage both dimensions.
Can I come in there, Anna, as well? Absolutely. And that's why I kind of made really stressed in the points that I brought out that actually it is about law firms, but it's also about the organisations that any lawyers work in. But it did actually, I've been recently speaking to a number of in-house lawyers on one-to-one and in panel events too. And some of them tell me that, that the in-house practice is a demonstrably different role to being in private practice. Those who've been in private practice and then move into in-house work. And within that in-house work, there's a whole range of different types of in-house work. It's not just one homogenous blob. And actually, I'm going to be a bit mean here and throw it back to Stephen again to say, actually, in terms of the public interest, is there any differentiation in your view to be made between what the public interest means for in-house lawyers and those in private practice? Is there any nuance here?
Well, in any organisational context, there's bound to be some nuance, I think. And this is a big topic, and there is a difference in the roles. But in principle, I don't believe that the public interest issues are different. It's true that a lawyer who is employed within an organisation can and probably should have better insight about the objectives, the drivers, the constraints, the politics of pursuing a particular course of action. But that would be my point. It's better insight. The in-house lawyer is still a member of a public profession with obligations to the public interest, the rule of law, and the administration of justice. So they still have duties to act with integrity and independence and to uphold public trust and competence. Otherwise, they're not a lawyer. So yeah, there may be undue pressure or conflicting incentives from within their organisation and pressure to flex their advice to suit internal imperatives, and they might need help in resisting that pressure. That's another different conversation. But we can't pretend that external lawyers aren't subject to internal pressures to do things that probably they shouldn't. Pressure from clients themselves, from partners, from their targets, from their own incentives. So I'm still back to that basic point. If you're a lawyer, you're a member of a public profession, you have these public duties. You may have to work differently to play them out properly and professionally, but you've got them. Professional bodies keep telling us that their members are competent, independent, high quality, and have integrity. They've got to live up to that. Thank
you. Our second question, directed specifically to Stephen, but I suspect may be of interest to others as well. I'm very grateful for Stephen's report and work. That's our question asker. I am too, though. I'm part of a group holding our profession to account for their role facilitating the fossil fuel industry. This includes through creative actions such as climate crisis exhibitions outside of law firm. We now live in an age of climate breakdown. Lawyers profiting from work with fossil fuel companies clearly goes against the public interest. What does Stephen think about holding law firms to account through public advocacy and creative actions? And obviously the reference to creative actions, they're thinking about how the post office scandal came to the public's mind, brings up thoughts there as well. But Stephen, perhaps if you could respond first, that would be great.
Yeah, and I suppose in some ways it's a mark of an obvious shortcoming if people outside the profession need to surface these issues and as in the case of the post office, just make them so obvious to people who are otherwise not mindful of what their own obligations might be. This is a tricky one for lawyers. And if any client is accused of committing a crime, then I think they are entitled to legal representation, however horrendous we might think their actions. Subject, as I said at the beginning, unless you're a barrister with a cab rank principle, you can make a moral judgment. You just don't want to act for that sort of client, and I'm comfortable with that. Beyond that, it all gets very tricky because some element of moral decision making is engaged. And as soon as that's engaged, you're open to very different and conflicting views based on different morals. So absent the criminal representation, absent, I would even say, every client who's thinking of doing something ought to be able to go to a lawyer and say, would this be legal? And again, I don't see a problem with any lawyer responding positively to that request to say, yes, it is, or no, it isn't, whatever their moral view might be of the underlying activity. The real problem for me is when the lawyers start doing things that are not illegal or enabling clients to do things that are not illegal, but might be morally reprehensible in the eyes of the wider public, or in this case, the sustainability of the planet. But I do think we need to be very careful not to impose our individual or even to some extent collective moral views on the activities of others. Otherwise, we're not living in a democracy and a free society. So all of this, the public interest itself, is a balancing act. I think there are some red lines that lawyers shouldn't cross, but there's an awfully large grey area where this moral compass issue is engaged, and there is no definitive answer to it. I think we've all got to reach our own view on what's acceptable and what isn't, and be comfortable with it. The problem for junior lawyers in firms, of course, is that the senior leadership might decide to do something that they are not comfortable with. The question then isn't, is the firm or the senior leadership doing something wrong? More likely to be, are you in the right place?
Thank you. We have another question actually about in-house lawyers or comment. I'm an in-house lawyer, and I think there is a heightened risk of forgetting the overall duties of them as lawyers. To my mind, there should be more regulation around them. One only has to look at the Post Office Horizon inquiry to see this.
Yes, I think there are two dimensions here. One is the view that the employer takes of the lawyer's role and the acceptability or otherwise of applying pressure to the lawyer to advise in a particular way. That is very much about the ability of an individual lawyer to stand up to that pressure, to speak truth to power, and to say, I'm sorry, I'm a lawyer, I'm regulated, I have obligations that go beyond this organization. You need to be very clear who your client is. It's often not the individual who you report to or who is applying the pressure. So again, yes, there are dimensions there. And I think that goes back to our earlier question about the difference in role between external and internal. So getting internal to understand the nature of a lawyer's job and their regulatory obligations is a key part of managing that relationship effectively. The second thing is an issue I addressed in the main report 4 years ago, which is at the moment there isn't a way for the regulators to regulate an in-house legal function. They can only regulate the individuals. And I think there's an element of regulatory policy there about whether there is a mechanism, or ought to be a mechanism, for being able to look at the entity of the in-house legal department to find a way of attaching some sort of regulatory responsibility from that group to the regulator on behalf of the public interest that allows the in-house lawyer perhaps to balance better the internal and the professional pressures.
Just chipping in, I mean, I don't know whether necessarily there's a case for regulation, but there certainly is a case for more guidance. I think that the in-house lawyer would welcome the opportunity to talk to or to rely upon guidance which might assist decision making. So let me give you an example. Internal investigations can be a real challenge for an organization. I think that the SRA draft guidance on internal investigations is a really good and thoughtful piece of work, which actually can support an in-house lawyer who might be put under pressure by strong management to take certain decisions in connection with the review of potential mischief. So I certainly think, I mean, and Stephen's outlined the difficulties around regulating the in-house function as opposed to the lawyer, but I think guidance which can inform individuals is potentially really powerful. And I cite that SRA draft, I think it is still a draft guidance on internal investigations as being a really good example, one that actually could be used by the in-house lawyer as support for a particular course of action, which would be the right course of action when confronted with senior management who may want to bury bad news or whatever they want to do.
Thank you. One question from me. On that point, apparently, and thank you to our audience member for this, the final versions were published on Monday, apparently. So wonderful. Yeah, one question from me, if I may. We've been speaking a lot about the importance, understandably, of identity, and in some of the responses we've been talking about the need to embed these changes. And it raises the question of how we change identity, but also this has come up a little bit in the responses to the questions as well. What happens if we have an identity of the profession, which may conflict with that of the organization, which may conflict with that of the individual? And grateful for your thoughts on how we manage not only the importance of identity at each of those stages of the system, but also if those are in conflict themselves.
Yeah, professional identity is another really big issue that could take us into another webinar. And but you're right that the problem, I think, in this is the alignment or the lack of alignment, and so that's why the transparency, the internal discussion, the explanation is so important. Because if you are, let's say, a junior lawyer with a sense of professional identity that doesn't fit easily with what seems to be happening at least in the firm, let alone the profession, then you need to be able to understand why that lack of alignment exists. And is it because you're not understanding, or because you think the firm either doesn't understand or doesn't want to understand, or deliberately wants to take a different position, probably for economic or market reasons that make you feel uncomfortable? So I'm not saying that you can always achieve that alignment, but it's a key psychological issue of how comfortable or not the individuals within a firm are. And without that explanation, without that articulation and discussion, we're never going to be able to get close to alignment. And that, I think, is where a lot of individual well-being issues become serious health problems.
I just wanted to come in there. Could I just add a couple of comments there, Anna, as well, which is about, this is where I think the culture and the ethical infrastructure of firms really helps. And it's organisations, whether they be law firms or other organisations, understanding that whilst kind of having these, ethical codes, policies about, you know, what your staff should do within your organisation are always helpful. It's that recognition that that ethical infrastructure has a formal part of it, the things that we can see, but it also has, you know, the things like policies, but it also is about the behaviours that we pick up from our colleagues, the behaviours that we pick up from our immediate leaders, what happens at the water cooler, what gets rewarded tends to get repeated. All of these things make a real difference, and that's why I kind of stress that point about senior leaders looking at actually how do we build an ethical culture within our organisation, how do we maintain it, what does it mean, what do we expect to see in our staff, how do we reward it, and also how do we provide a means for, as Stephen said, staff to speak up, staff to talk about ethics, because actually these are tricky decisions, some of these balancing these tensions and demands that lawyers have in practice. And sometimes, you know, individuals need to be able to bounce those ideas and have that reflective ability of the opinions of others too. So space to do that would be my big ask of law firms.
Well, on that note, I think, alas, it is time to draw today's discussion to a close. I obviously wanted to extend a huge thank you to our panel, to Stephen for such a wonderful and important report, and to Karen and Sam for their insights and expertise. And indeed, we look forward to the task force report when it comes out next year as well. Thank you to our audience and for your questions, and wishing you all a very good afternoon, and thank you very much.